Good afternoon. How's everybody doing? Great to be learning with you on a Thursday, Yom Hamishi. Let's light up the darkness. You might have noticed there was no music playing. And thank you to Sharon for giving me a gentle hint yesterday, asking me what's the rule with music during the 3 weeks. So first of all, there are different opinions on that. I checked with my Rav. So my Rav says, yes, you can listen to a cappella music if it's not the kind of music that's going to lead you to dancing. And the music that we always listen to or have for the last year during the 2-minute countdown is Moshe Storch leading our shul in a Hallel. But he was playing the guitar, so it was not a cappella music, and it would not qualify for this. And once I said, okay, we're not going to do music, I could find some a cappella music, but why not just go back? We'll have a little throwback to the jungle rainforest sounds that I was playing during my year of Avelis when I was saying Kaddish for my mom, and we'll use that with God's help until Tisha B'Av comes in a little less than 3 weeks. So that's what was going on there. Okay, who's in the house? Stephen in New Hampshire, Yehuda in South Carolina, Shandora in the Bronx, Lorraine in Texas, Bella in Florida, Melissa in Great Neck, John in Maine, Tom in Pennsylvania, Joe in the Inland Empire, Sharon in New Jersey, Paul in the Great Northwest, Ryan in Jacksonville, Bill in mid-Missouri, Lucy in Minnesota, Nancy in North Carolina, Leona Sue in southern Illinois, as well as Ella and Ilanit in Silver Spring, and Marie in Freeport, and Marjorie in Georgia. Welcome, everybody. Let's get busy. Our daf today is page 31, page Lamed Aleph, here in Tractate Bava Basra, 23rd volume of the Talmud, working our way through chapter 3, Mishna number 1. We picked this up right near the top of page 31a. There was an incident where, and this whole Mishnah at the beginning of chapter 3, we've been talking about the chazaka, the presumption of ownership that is established after somebody occupies a house or a business, real property, for 3 years. Then, even if he doesn't have evidence, he lost the purchase and sale agreement when he bought the land. Nevertheless, the fact that he's been there, either living there or renting it out or farming the field or using the olive press for those 3 years, continuously 3 full years, so this establishes the presumption of ownership. And if somebody's going to come along and say, hey, that's not your land, you didn't buy it from me, I'm the owner of that land, then even if he can show that he was the previous owner, nevertheless, he's going to have to bring proof that the one who's now possessing it, took possession illegally, because the presumption of ownership after 3 years belongs to the one who is in possession of that land. So to dislodge him, the claimant will have to bring evidence. If the one in possession of the property has been there for less than 3 years, then he's going to have to prove it. The burden of proof is on him if indeed the one who brings the claim is able to show that the land was his before. Now the one in possession is going to have to prove that it's his legally, or he will be dislodged. Okay, there was an incident where 2 people disputed the ownership of land. This one says, the land belonged to my ancestors and I inherited it from them. And the other one says, the land belonged to my ancestors and I inherited it from them. And this one brings witnesses that the land belonged to his ancestors, and that one brings witnesses that he currently possesses the land and that he worked and profited from the land for the years necessary for establishing the presumption of ownership. Okay, so both of them claim that they inherited from their ancestors. One has witnesses to the effect that he inherited from the ancestors. The other one has witnesses that he's been in possession of it for more than 3 years. So then what? Rabbah said the judgment is in favor of the one in possession, due to the legal principle that if the judgment would have been decided in one's favor, had he advanced a certain claim, and he instead advanced a different claim that leads to the same ruling, he has credibility, as why would he lie and state this claim? In other words, he could have brought a stronger claim. He brought a weaker claim. It's still, a claim that leads to this outcome, but he had a stronger claim available. He didn't offer the stronger claim. Why didn't he do that? Must be that he's telling the truth. This is usually called migo, but sometimes it's literally called why would I lie? Right? In other words, why would I lie and offer this weaker claim when I had a stronger claim available to me? If I'm a liar, I would have taken the stronger claim. What I'm telling you must be the truth. And so in this case, it's the truth. So if the possessor, so what would the lie have been? The stronger claim. If the one in possession wanted to lie, he could have said to the claimant, I purchased the land from you, and I worked and profited from it for the years necessary for establishing the presumption of ownership, in which case he would have been awarded the land because that would have been the best claim of all. It wouldn't matter that the other one has witnesses that it used to belong to his ancestors and he inherited, because this other one is making the claim that, and I bought it from you, and I've been here for 3 years, so now dislodge me if you can, and the guy won't be able to, and the one in possession would have been able to keep it. Instead, he just brought witnesses to say, I've been there for 3 years, not as strong, but he's been there for 3 years. Now, Abaye said to Rabbah, we do not use this principle of why would I lie in a case where there are witnesses contradicting his current claim, as they testify that the land belonged to the ancestors of the claimant. Therefore, he should not be awarded the land. Now, what he said was, I inherited it from my ancestors, and what he brought witnesses of is that he's been living on it or possessing it for more than 3 years. The other one has witnesses that he inherited from his ancestors. Now, do these witnesses contradict that this guy's been in possession for 3 years? No, but they do contradict that he said, I inherited it from my ancestors. How could they both have inherited it from their ancestors? So that seems to be a problem. Now, the possessor then said to the claimant, yes, it is true that the land belonged to your ancestors, but it is also true that I purchased it from you. And by stating that which I said to you, that it belonged to my ancestors, I merely meant that I rely upon my ownership of it as if it belonged to my ancestors. Why? Because I purchased it and then profited from it for the years necessary for establish the presumption of ownership. That sounds a little fishy, right? He's saying, well, I used the expression, I inherited it from my ancestors, but what I meant was, I have solid ownership. It's the same as inheriting it from my ancestors. Why? Because I bought it from somebody who inherited it from his ancestors, namely the claimant, right? The one who's coming here and saying it's really his. He's saying, yeah, but I bought it from you. The other guy's denying that. And it's a he said versus he said situation. But what we're now talking about is, can you change your story in court? Doesn't that sort of automatically disqualify you when you're changing your story? Not necessarily. Because sometimes people just don't express themselves clearly, and it's not the same as contradicting themselves. And that's what they're arguing about now. Right, so when I said that the land belonged to, when I said that it is true that it belonged to your ancestors, but I purchased it from you. And when I said to you that it belonged to my ancestors, I merely meant that I rely upon my ownership of it as if it belonged to my ancestors because I purchased it from you who inherited it from your ancestors. Now the Gemara asks, can he state a claim and return and state a modified version of his claim? Or can he not state a claim and then return and state a modified version of his claim? Ula said he can state a claim and return and state a modified version of the claim. That's important, that you can change your story a little bit as the facts come out and you're just, able to express yourself better. It's not because you were lying. It's because the issues are becoming more clear. Not everybody understood what was happening until we got in and had all the testimony. Now, that's different than telling one thing and then later telling another thing, and the two statements are contradictory. One is a modification of the first. A totally contradictory statement would not be given any credence whatsoever. So Ula said, yes, he can state a claim and then return and state a modified version of the claim. And the sages of Nehardea say, no, he cannot state a claim and then return and state a modified version of his claim. Whatever claim you make in court, you can't then modify it as you see that claim is not going to be enough to win the day in court, as it were. Now, we can sort of sit on our soapbox and say, hey, if he's telling the truth, why would he change his story in court? But litigation is tricky, and you will find all the time that when parties litigate and when prosecutors face off with defense attorneys in court, that they will often bring multiple arguments, right? Well, my client is innocent because he wasn't there. But even if he was there, he would be unable to commit the crime because, he's too short or too tall or whatever, right? They can have multiple stories that aren't necessarily going to coexist. Not all of these arguments can be true, and yet they're all brought because that's the nature of litigation. Okay, but here we see that one sage said he can modify his story. Ula said he can modify his story. But the sages of Nehardea say no. Whatever claim you bring at the beginning, that's your claim. If you then need to modify it in order to win, you lose. Now, the Gemara clarifies their respective opinions. And Ula, who says you can modify your claim, Ula concedes that in a case where he had initially said to him, the land belonged to my ancestors, and it did not belong to your ancestors, that he cannot state a claim and return and state a modified version of the claim, as Ula allows the litigant only to reinterpret his initial claim, not to replace it with a contradictory claim. And Ula also concedes that in a case where he was standing in court and did not make a particular claim, and he later came in from outside and back into the court, and he stated that claim, that he cannot return and state that claim. And what is the reason for this? It is because it is apparent that these claims of his were taught to him by someone after he left the court, right? So now remember, when we talk about modern litigation and prosecutors and defense attorneys or plaintiff's counsel and defendant's counsel, that's not the way these claims were litigated before a Beis Din, right? Before a rabbinic court, they didn't have lawyers, right? So they just came, and the litigants, appeared before the tribunal, of the rabbis who were serving as judges, and told their stories. So if somebody left the court and then came back, with an argument that works much better, but it was obvious that he received some coaching, from somebody who knew the halacha better than he did, that's not going to work. All they're saying is, okay, look, did you say what you meant? Were you using, just an expression that wasn't exactly what you mean? As they get to the bottom of exactly what the litigants are saying, the story can change a little bit as long as it's not contradictory, not self-contradictory between one statement and another statement, right? In other words, people, they don't always speak with precision. That doesn't mean that they're liars, okay? Okay, now, and the sages, right, so the Ula says you can change your story a little bit. The sages of Nehardea say, no, whatever claim you make first, that's your claim, and you can't change it. And the sages of Nehardea concede that in a case where the litigant who changed his claim said to the other litigant that when he had initially claimed the land belonged to my ancestors, he had actually meant it belonged to my ancestors who purchased it from your ancestors. Well, there's no contradiction there. It did belong to his ancestors, and then he's adding information that it belonged to my ancestors, and it also belonged to your ancestors, but my ancestors purchased the land from your ancestors. That's why I'm the legal owner now. That's okay. That's a legal claim. There's no lie there. There's no contradiction. He's just adding information. And so the sages of Nehardea would allow that kind of a modification. Because this modified version of the claim serves only to clarify, not to negate his original claim. And the sages of Nehardea also concede that in a case where he discussed the matter outside of the court and did not state a particular claim, and then he came into the court and stated that claim, that he can return and state that claim. And what is the reason for this? Because a person is apt not to reveal his claims except to the court. I'm not sure how that explains why you would allow somebody who didn't make a claim to then step outside during the litigation, come in and add a new claim. And what they're saying is he didn't receive coaching outside. He just hadn't got around to mentioning this. We had a recess. Okay, he might have had a chance to speak to other people, but that doesn't mean that he did or that he got coached, because people don't usually talk about what's going on in the court outside of the court. A Maimar said, I am from Nehardea, but I nevertheless hold that a litigant can state a claim, go outside, and return and state a modified version of his claim. And the Gemara concludes, and the law is that a litigant can state a claim and return and state a modified version of his claim. Doesn't mean that he was coached. It just means that he hadn't finished making his claim the first time. We're not going to assume that he's a liar. Now, in an incident where two people dispute the ownership of land, and this one says the land belonged to my ancestors and I inherited it from them, and that one says the land belonged to my ancestors and I inherited it from them, and the first one brings witnesses that the land belonged to his ancestors and that he worked and profited from the land for 3 years necessary to establish the presumption of ownership, and the second one brings witnesses only that he worked and profited from the land for the years necessary for establishing the presumption of ownership. Okay, got it? Both of them claim it belonged to their ancestors and they inherited from their ancestors. The first one has witnesses that it belonged to his ancestors, that he inherited from them, and that he's been living and working there for 3 years. The second one claims it belonged to my ancestors and I inherited it from my ancestors. And then he also brings witnesses, but his witnesses can only attest that he was living there for the last 3 years. Now, one of these pairs of witnesses is wrong, right? Because they can't both have been living in the same residence for the last 3 years, to the exclusion of the other, which is what they're both claiming. So one of these witnesses is either one pair of witnesses is either mistaken or lying, right? But there is a stronger claim because the first guy has witnesses both to my ancestors owned it and I inherited it and I've been there for 3 years. The second one only has witnesses for and I've been living there for 3 years. So then what? In that situation, Rav Nachman said, establish the testimony with regard to profiting by the first litigant alongside the testimony with regard to profiting by the second. And the two testimonies cancel each other out. We don't have a dispositive answer with regard to who was living there for the last 3 years, because they both have a pair of witnesses making that claim, and those two claims contradict each other. We don't know who's been living there for the last 3 years, because we have, a complete set of witnesses for both arguments, so these are going to cancel each other out. But the first guy has an additional testimony from his witnesses, right? So the two, regarding who's been living there for the last 3 years, those two sets of testimony cancel each other out. But we still have the testimony with regard to ownership by the ancestors and his inheriting from them for the first litigant. And that's not contradicted by any witnesses brought by the second one. So we cancel out the conflicting testimonies about who's been living there for the last 3 years. And then the first litigant, his witnesses testifying that his ancestors owned it and that he inherited from them, that's the surviving testimony, and therefore he wins the litigation and he gets the property. And therefore establish the land in the presumptive ownership of the litigant who brought witnesses that it belonged to his ancestors. Rava objected to this and said to him, "This testimony cannot be relied on, as it is contradicted by the other testimony." Now, maybe the guy with the witnesses that his ancestors owned it and he inherited from them and he's been living there for 3 years, those witnesses are telling the truth. And the other guy who says, "I inherited and my ancestors owned it and I inherited," but he doesn't have witnesses for that. He only has witnesses for, "and I've been living there for the last 3 years." So maybe those witnesses are liars, and therefore the first guy should own the land. But we don't know if the witnesses from the second litigant who's saying that, testifying that he's been living there for the last 3 years, maybe they're not the liars. Maybe the other set of witnesses are the liars, right? Because definitely both parties haven't been living there for the last 3 years. So one of these sets of witnesses is lying, and we don't know which. Since we don't know which, how can we rely on this pair of witnesses who might be the liars, who are saying not only that this guy's been living there for the last 3 years, but also that his ancestors owned the land and that he inherited from them? Since we don't have the basis to know that those witnesses are entirely credible, since there are 4 witnesses here and 2 of them are at least mistaken, if not downright liars, we don't know. And 2 of the 4 are not reliable. How can we rely on anything from any of these witnesses? That's Rava's argument, and it's a good one, right? Rav objected and said to him, "The testimony cannot be relied on, as it is contradicted by the other testimony." Rav Nachman responded to Rava and said to him, "Although it is so that the testimony was contradicted with regard to who's been living there for the last 3 years, was the testimony contradicted with regard to ownership of the ancestors?" And the Gemara asks, well, shall we say that Rava and Rav Nachman disagree regarding the same issue that was a dispute between Rav Huna and Rav Chisda? Okay, so where Rav Nachman and Rava are, arguing about where we have 2 issues, who's been there for the last 3 years and who inherited from his ancestors, and this guy has witnesses for both of the issues, and this guy has witnesses only for one of the issues. So Rav Nachman says, okay, well then the issue about which one guy has testimony and it hasn't been contradicted, that's going to win the day. Okay, that was Rav Nachman. Rav said, yeah, but these witnesses are not guaranteed reliable. How can we say anything according to them? That's what Rav said. Now, we're going to discover that this argument has a parallel to a dispute between Rav Huna and Rav Chisda. So what did they say? As we stated concerning 2 groups of witnesses, now we are on 31b. Regarding 2 groups of witnesses that contradict each other, Rav Huna says, this one comes to court on its own and testifies, and that one comes to court on its own and testifies. Despite the fact that one group certainly testified falsely, which would serve to disqualify one of the groups, each group is able to testify in another case. Right? In other words, we had 2 sets of witnesses come and contradict each other. So one of those sets is testifying falsely, but we don't know which. So all we know is that 2 of these 4 witnesses are at best mistaken and possibly liars, but we don't know which, and we have no way of knowing which. So the question is, are we going to say that all 4 of these witnesses, 2 of whom, as far as we know, are telling the truth? But are we going to say that since it's possible that 2 of these 4 witnesses are liars, that and we don't know which, that we're going to disqualify all 4 of these witnesses from testifying in some other matter? That's the question, right? So Rav Huna says no, because all we really know is that 2 witnesses came and gave testimony. 2 witnesses came and gave testimony. They came on different days, perhaps. I don't know that matters. But we don't know for sure that either group is testifying falsely. We don't know who's being false. We don't know. So since we don't know that they're false, we can't say that all 4 of them are disqualified from testifying in other matters. We're not going to ruin their reputation that way, since 2 of them are for sure not false. So Rav Huna says, okay, so all four remain qualified to testify in other matters. We simply say that because their testimonies contradict each other in this case, we don't have an answer in that case, but neither do we disqualify all four from testifying about other matters. And you can see how that would apply to our case. Okay, so with respect to who was living in the house for the last 3 years, we don't know an answer because there's two sets of testimonies that contradict each other. But with respect to whose ancestors owned the land and who inherited from those ancestors, only one set of witnesses testified about that. They haven't been contradicted, so we're going to accept it according to this principle of Rav Huna, despite the fact that one group certainly testified falsely, which should serve to disqualify one of the groups. Each group is able to testify in another case because we haven't definitively disqualified anybody. And so that's Rav Huna. Rav Chisda says, why do I need these lying witnesses? In other words, they're all disqualified to testify in another case until it is clarified which of them had testified falsely. And the Gemara asks, shall we say that Rav Nachman is the one who says his ruling in accordance with the opinion of Rav Huna, that we don't disqualify all four just because two of them seem to be false, but we can't say that all four are therefore disqualified, because then we would besmirch the reputation of two people who are telling the truth. And Rava seems to hold in accordance with the opinion of Rav Chisda that says, well, we definitely know that two of these four are false, so how can we trust any of the four? That is what Rav Chisda says, and it seems that Rava is ruling in the case of the witnesses for the property according to the principle established by Rav Chisda. So the Gemara explains, according to the opinion of Rav Chisda, who holds that all the witnesses are disqualified, so everyone agrees that the testimony concerning ancestral ownership is not accepted, as the witnesses were contradicted concerning their testimony of who was living in the land for the last 3 years. And Rav Nachman's ruling cannot accord with his opinion. When Rav Nachman and Rava disagree, it is according to the opinion of Rav Huna, who does not disqualify the witnesses. The ruling of Rav Nachman is in accordance with the opinion of Rav Huna, and he therefore accepts the testimony with regard to the ancestral ownership, since that was not contradicted. And Rava would say, Rav Huna says that the witnesses are accepted only for another testimony, i.e. in some other matter, some different case. It doesn't mean we're going to allow them to testify about a different issue in the same case, but they are not accepted for this same testimony. That's what Rav Huna would say. Now the Gemara relates the continuation of the case above. The one who brought witnesses only to him living there for the last 3 years, then brought witnesses that it had belonged to his ancestors, thereby balancing the evidence for the two litigants. Therefore, Rav Nachman said, we previously brought down to the land the one who initially had evidence of ancestral ownership to take possession of it, and we now bring him up from it, removing him from the land. And we are not concerned about the possible contempt of court that might result from perceived indecisiveness. Because it wasn't indecisiveness, new evidence was introduced. See, once you had conflicting testimony about both who lived there for the last 3 years and whose ancestors owned it and who inherited from the ancestors, both sides have witnesses for both issues. Well, then who's going to be dislodged? I mean, right? Presumably, the one who's in possession of the land can stay because everybody has the same amount of evidence. But one of the guys is actually living in the house, so there's just not going to be, no one overcame no one had greater evidence to dislodge him, so presumably he can stay. Now, Rava, and some say it is Rabbi Zera, raises an objection from a Baraisa. If there was a married man whose fate was unknown, and two witnesses say this married man died, and two witnesses say he did not die, or if two witnesses say this woman was divorced and other two witnesses say she was not divorced. So we have conflicting testimony about whether a woman became a widow or not, or a different case, whether she became a divorcee or not. Now, why does it matter? Because if she's a widow, she can remarry. If she's not a widow, she cannot remarry. Again, if she's a divorcee, she can remarry. if she's not divorced, she cannot remarry, right? Because if she's not divorced and she's not a widow, she's still married. So she can't go marry some other guy. And the conflicting testimony is a huge problem for her because she cannot remarry. But since it is conflicting, we have an uncertainty that she actually is either divorced or a widow, depending on the case. So because of that uncertainty arising from the conflicting testimonies of two sets of witnesses, she is not permitted to remarry until more evidence comes so that we can say which witnesses was telling the truth. So this one, so in that situation, with that uncertainty in place, she may not marry, as there is not unequivocal testimony that she is no longer married. However, she's not allowed to remarry. But if she does remarry, the marriage is valid and she need not leave her husband. And Rabbi Menachem, the son of Rabbi Yosei, says, what are you talking about? We're not going to say that, she's not allowed to remarry because of the uncertainty of whether she still is married or not. But if she went ahead before this, ruling came from the court, before it was clarified, before the two testimonies came in front of the court, and she just went ahead and remarried, we're not going to make her divorce. And Rabbi Menachem says, why not? Of course we had to pull her out of that second marriage because she wasn't permitted to enter into it. So we do dislodge that second marriage. And that actually is the law. Now, Rabbi Menachem, the son of Rabbi Yosei, said, when do I say that she must leave this second husband? She must leave him in a case where witnesses came to testify that she is still married, and she then married despite their testimony. But if she married and then the witnesses came to testify that she is still married, but she also has witnesses to testify that she can remarry, but the ones that would throw this into uncertainty only came after she remarried, then she doesn't have to leave the second husband because she didn't enter that second marriage during a time of uncertainty. Only the first set of witnesses that come saying, yeah, your husband died, or yeah, this woman is divorced. And so she was permitted to remarry. She did remarry. And then these other two witnesses came and said, no, your husband's still alive. Or you actually weren't divorced. Then we don't make her leave. But if those two witnesses that say, you're still married, or because you were never divorced, or because your husband is not dead, if they came before she remarried, then we make her leave the second husband because she should not have entered into that marriage with this uncertainty hanging over her head. That's what Rabbi Menachem, the son of Rabbi Yosei, ruled, and that's the law. Now, Rav Nachman said to him, and I'm almost done for today, so if you got questions or comments, please get them in. Rav Nachman said to him, I had thought to perform an action and reverse the court's ruling, but now that you raise an objection against me, and Rav Hamnuna also raised a similar objection against me in Syria, I will not perform an action in this matter. And the Gemara relates that Rav Nachman then went out and performed an action, taking away the land from the litigant in whose favor he had previously ruled. And one who saw what he did thought that he had made a mistake, but that is not so. Rather, he performed an action despite the objections that had been raised, because the matter depends on great authorities, Ashle Rav Reve, since, as the Gemara will demonstrate, this issue is subject to dispute between great authorities, and he relied on those that supported his opinion. And we're going to go into that case tomorrow, God willing, at the regular Friday time of noon Pacific, right? So we're talking about different kinds of uncertainty that can be created. We started by talking about uncertainty because you have contradictory testimonies coming from two sets of witnesses, right? So two witnesses came and said, this guy owns the property. Two other witnesses came and said, that guy owns the property. We can't figure out the truth. At that point, we're not going to dislodge the first. Then we have a question, do we discredit all four witnesses since two of them are at best mistaken and probably lying? Should we say, well, two of the four are probably lying. How can we listen to any of these four in any other case? Answer, we can listen to them in another case because we never established who the liars are. but maybe we shouldn't listen to them on separate issues in the same case. And then we talked about a woman, who it's unclear whether she is single either as a widow or a divorcee, and whether she can remarry or not, because we have contradictory testimonies from two sets of witnesses. Then what are we going to do? So their part of the equation is, yes, well, when did the uncertainty begin? When did the second set of witnesses arrive? Did she take an action before that or after that? That will be dispositive of whether we make her leave the second husband or not. Now, when we go into it tomorrow, we're going to talk about further kinds of uncertainty that can be created either by witnesses, sometimes by two witnesses, which is what's usually required to establish a matter. But in some cases, we can even listen to the testimony of a single witness. But also in cases where, which was just alluded to, he wasn't sure what the law was because he hadn't heard a ruling. And then he did hear the ruling later that clarified the law for him. Is he going to go and reverse himself in front of his litigants? And perhaps a humble, truth-devoted judge would reverse himself when he learned a law that he wasn't familiar with at the time that he issued his first ruling. Okay. Nina is got another issue that she's dealing with, so she's not passing me questions and comments. So I'm going to be scanning the comments on Facebook and YouTube, which takes me a little bit of extra time. Okay. Joe, when someone goes to the Beis Din, to the rabbinic court, do they have to pay the rabbi's time, or are the rabbis at the service of the community and a stipend is given to them from the community? Excellent question. I think it really depends on the Beis Din, but I think generally speaking, it's sort of like arbitration. They do have to pay a little bit of money just for the court's time. But of course, it's going to be done in such a way that it can't influence the judgment, right? That both litigants would have to pay, some small and equal fee, very transparent. And that I believe that's how it's done. I mean, I thank God I've never had to appear before a Beis Din, in a what's it called? In any kind of antagonistic proceeding. I once served on a Beis Din for a small matter where a layman was permitted to serve on a Beis Din, but it wasn't this kind of issue. And sometimes it's just done by the rabbi and the assistant rabbi of your community. But where you have a complicated issue, so it's going to be a higher level Beis Din. And I mean, they have to be paid. It's not that they do that just fulfilling some kind of halakhic moral obligation. I think a Beis Din gets some kind of payment, but believe me, no rabbi's getting rich from serving on a Beis Din. It'll be some nominal fee. So if somebody knows better, please let me know. That's my understanding of it. Doesn't seem to be a question. Okay. And on YouTube, doesn't seem to be a question. But I am seeing from Rochelle, good evening from Modesto, California, where we have 100 degrees plus weather for over 13 days. Whew. Stay cool. May you stay cool. Isn't it amazing, though? I've been thinking about this a lot lately. That people lived in Palm Springs. People lived in Phoenix. People lived in Tucson. People lived in Las Vegas, 150 years ago when there was no air conditioning. I don't know how. And not only did they live there, they wore wool. We're so soft, we can't even contemplate such a thing. Anyway, that's what I've got for us today. With God's help, we'll be together again tomorrow, Friday, at the regular Friday time.